Canada's top court heard a landmark privacy law case today. It's about Facebook's role in a major data controversy that involves the harvesting of personal information of more than 500,000 Canadians. Facebook's parent company, Meta, is appealing a ruling that found it broke federal privacy laws by failing to tell users about the risk to their personal data. It stems from a scandal involving a British political consulting firm called Cambridge Analytica. The company was caught improperly harvesting data from tens of millions of Facebook users without their consent. The Supreme Court did not make a decision on the case today. It may be a few months until it does. For some more context on this case and some advice on how to better protect your data, I want to welcome Claudiu Popa. He's the Managing Director of privacy management company Managed Privacy Canada, and today he joins us from Toronto. And Claudiu, appreciate you taking the time. Thank you.
Thanks for having me on the show, Andrew.
So this is a landmark legal case against Facebook and its checkered past with protecting user privacy. How did we get here?
Well, it's been a long road, quite frankly, because privacy is baked into our laws, and our laws take a long time to make their way through the courts. But in fact, this issue started back in 2011, 2012, 2013, and it lasted right up until about 2015 when users started to realize or were notified of the fact that one of those miscellaneous little apps that everybody loved to have installed in their Facebook accounts was actually harvesting data, harvesting personal information from them. And a lot of that personal information included not just their PI, their personal information, but that of their entire network. And so even though fewer than 300 Canadians were directly impacted, something like 600,000 other Canadians were indirectly impacted and had been profiled by virtue of Facebook sharing this data with a political profiling company that you identified as Cambridge Analytica.
So what work is Canada doing to ensure that breaches like this do not happen again?
Well, I was as shocked as other Canadians to find that this was going on and that there's an entire ecosystem of data sharing that was facilitated by Facebook. And the privacy commissioner went to town and did their investigation. They said quite correctly that that this is a matter of consent. Fundamentally, Canadians have a right to consent, but that consent has to be meaningful. It can't be passive, and it needs to be informed. And what that simply means is if practically all of those Canadians knew that their data was being harvested, they certainly would not have wanted to share it. And so today's case that's being heard as a result of the Court of Appeals upholding the fact that this was not a case that included meaningful consent is critical for literally everyone's privacy rights in Canada. So I certainly appreciate the fact that you're covering it.
And so what are other countries doing to protect online privacy that we could learn from?
Well, that's an excellent question. In the USA, unfortunately, there is no federal privacy legislation, so they would not have access to what we have and what we know as PIPEDA or PIPEDA here in Canada, which is really the protection of personal information. So we bake in the protection of personal information right into the name of the law. And no other country has it baked into their name like that. Obviously, we have really strong privacy legislation in Europe as part of the GDPR, where it's actually enforceable. Here in Canada, unfortunately, our privacy commissioners, as powerful as they are and as helpful as they are in articulating these cases, they can't make decisions about enforcement or fines. But Europe can. And that's kind of where privacy reform is going in Canada. It's already happening in Quebec, and that's certainly appreciated. Other provinces are looking to follow suit, so that's fantastic. But in the meantime, we always recommend that users protect themselves as much as possible, if only because the more they tighten their privacy, the more it's clear that they care about privacy. So you won't have a platform that comes and says, well, you didn't change the defaults, therefore you must not care. If you show that you've tightened those defaults and you go through those settings, it will show that had you been given the option, you would have refrained from providing consent for data collection and sharing.
Okay, so I was going to just ask you, I think you're getting at it, but in the meantime, what can individual users do to protect their privacy?
Yeah, that's exactly right. So the first thing is to protect their account. Their account is central to their identity protection. It prevents identity fraud. It ensures that you have control of your personal data. And it, of course, controls all of your activities online. So make sure that you enable that two-factor and multi-factor authentication. The second thing to do is to go through those privacy settings, as I said before, and tighten them, because you'll be surprised what's in there about sharing data with advertisers and other third parties. And the interface changes on a regular basis, and so many people fall behind because it's a little bit tedious. And third, when you do visit websites, not just social media, but any website of any company, make a point of reading or skimming their privacy policy and ask questions, because if you are not satisfied with the degree of consent that is required of you, chances are your data might be collected and shared without your approval or your knowledge. And at that point, you can appeal to the Privacy Commissioner to investigate. And I always recommend that people take that opportunity because it's available to them.
Claudio, appreciate this thoughtful conversation. Thank you. That's Claudio Popa, Managing Director of privacy management company Managed Privacy Canada.